Hello, I'm Martin Rogers. I'm a partner of Clifford Chance. I'm the head of our litigation practice in Hong Kong and Asia. I'm also the general editor of the Hong Kong White Book, published by Sweet and Maxwell. I'm going to talk about expert reports, the giving of expert evidence under the new civil justice rules coming into force in Hong Kong on the 2nd of April 2009. What's new? I think most people know the main things which are new. We're going to have a new court-imposed single joint expert, notwithstanding the parties' disagreement or objection in appropriate cases. There's also a brand new code of conduct which isn't actually that brand new in the sense that it replicates what's already in the well-known Icarian RIFA decision. But I don't want to talk about those. I want to talk about something which, in my view, is a little bit more hidden and a little bit more difficult to deal with, and arguably much more controversial than either of those two developments. What I want to talk about is statements of truth as applicable to experts' reports. Order 41A deals with statements of truth. Now, when I think about statements of truth, having lived through the civil justice reform consultation procedure, I just tend to think about pleadings. The statements of truth under Order 41A are not just concerned with pleadings. It's concerned with pleadings, witness statements, and experts' reports. And it's experts' reports that I want to focus on. Order 41A, Rule 4, says this, and it says this about all three, pleadings, witness statements, and experts' reports, that the maker of the document must believe that the facts stated in the document are true, and, if applicable, which is talking about experts' reports, that the opinions stated therein are honestly held. So what does that mean for the expert if his report has got to contain a statement of truth by him that he believes the facts are true? There's a real conundrum in this. The expert is being brought in as an independent, objective party, an expert who wasn't fundamentally involved in the disputed facts. So how is he expected to give a statement of truth in respect of those potentially heavily contested facts when he wasn't actually involved in the events in question? I think the answer is a practical, pragmatic one. It's going to have to be dealt with on a case-by-case basis. Let me give you a couple of scenarios to explain what I mean. First, a case where an expert wasn't involved in any respect at all in the underlying facts. He's coming in to express an opinion based on documents, based on material that's put before him for the first time when he's asked to give his opinion. There are also facts which were in the past and which there's no way for him to do any real due diligence to verify whether they're correct or not. A forensic accountant, in certain circumstances, might be a good example. Now, what I'm going to do as the advisor instructing that expert is to make sure that his report is suitably qualified so that he's giving his opinion based on assumptions as to what are the true facts. All he therefore has to do is give his statement of truth in respect of his opinion, not the underlying facts. That must be the right approach. And if we don't have that approach, then you're going to have a lot of experts who would have been prepared to give evidence under the old system, simply not prepared to do so under the new system, because they're effectively giving a view which might be relied on by the court and might result in potential liability in extreme cases. But the second scenario is one where the expert may be involved in giving statements of truth in respect of actual facts. The classic example would be a doctor examining a patient who suffered an injury which is claimed to be because of some tortious negligence on the part of the defendant. Now, the doctor's examination of the patient is actually establishing underlying facts. The examination, what happens, what is diagnosed by the doctor, is a fact which will be put before the court. Obviously, the doctor's in the best position, probably the only position, to verify those facts. Having said that, even in his case, there's going to be a medical case history, examinations by previous doctors, upon which he's going to have to rely, and similar qualifications to his opinion should be built into his report. Sounds simple, but it is a real issue, and it's going to involve a lot of consideration by lawyers in what may be quite technical circumstances. But let's see how it goes. Thank you.